The Ato Forson Ambulance Trial. A number of questions arise. We want to find out if the third accused, Jakpa Richard, entrapped Godfred Dame, the Attorney General, seeking to damage his reputation unfairly and to botch the trial. How is that argument of entrapment sustainable? Now we know Richard has sworn to an affidavit placed before the court and says other things, unprintable, that Godfred Dame had assured him that he was not the target of the prosecution, but Ato Forson, and that he was under pressure to prosecute Ato Forson because certain individuals in government, including the president, were pushing for it. Did Godfred Dame do anything wrong if these conversations are what they are as played to the public? Some say he did a criminal wrong and he misconducted himself professionally. Others say he did absolutely nothing. There's two sides are on the show this morning. The Pwalugu Multipurpose Dam. At the Public Accounts Committee, developments, including revelations of the spending of almost $12 million US, with nothing to show for at the site of the dam, came up and got many Ghanaians angry. There's an explanation to it. The money has been spent on drawings and other things. How do they justify this explanation? I'm Samson, Lardy, Anyenini. We'll be right back to deal with the vexed matters. Welcome back. And here is Samson's take. There's a question to the president. What happened to Akufo-Addo? I've gone into my 2016 archives for Newsfile to confirm the scandal a day or each week is not exactly strange. I saw how MPP MPs and communicators brought many things to my attention in that election year, and that's very regular. They would share documents and allegations of wrongdoing, especially corruption in the Mahama government. They will be persistent in their pursuits. They will make the news and literally lead the media debates. There were people who were almost always sleeping in these premises. I find NDC bigwigs do not do as much in this area. I remember, for example, how Gabi will file tons of things. Candidate Nana Akufo-Addo will join in condemning the rot and make citizens extremely proud. Very proud, I must confess. Then he will make corruption the major plank of his campaign, and he will be loved. I recall the joy in my heart hearing him, and I suppose you felt the same too, hearing him repeat his caution that those whose agenda was to make wealth or seek wealth in public office will not have a place in his government if he won power. Sir, sorry, I just had a meeting with you, but I didn't bring this up. Your appointee, Brian Achampong, is the sole owner and beneficiary of Rock City Hotel, seeking to take over 4 Senate hotels in bizarre circumstances. Some of these hotels are more profitable than his own. You have heard Brian Achampong say publicly that he is not paid by the hotel, blah, blah. Remember, he's a sole owner. He's paid dividends as shareholder. Let's say he takes us all for fools. Dividend is emolument. By Articles 78 and 98 of the 1992 Constitution, he is not to engage directly or indirectly in anything for emoluments as a minister and as an MP without a certificate by the Speaker allowing him to do so. This certificate will only be issued after a committee has determined that there will not arise conflict of interest with his offices as a result of his private business. Sir, you have not, consistent with your campaign commitments, said a single word. This will not be the first time you disappoint the millions who repose such great deal of trust in you in 2016. I have many times and for a long time asked if these scandals are simply things blown out of proportion by Ghanaians who are a very difficult people to govern. Yes, there are times I can't appreciate the hue and cry over easy to understand matters, like this fresh contract between the Ministry for Communication and those entities. People are raising issues. And the first issue is that this company was incorporated on the 18th of August or so, and that by the 22nd or so of August, you, the president, issued them the power and the contract to do these businesses. And they say that's a company, that's a day-old child. What people can't appreciate, which is easy to, is that this is a consortium. It's a group of companies with expertise that have come together under one umbrella. So there is no crime if their registration documents show that they are supposed to do 5G nationwide. That is not to say there was collusion before they got registered, because that's basic. If there is some wrong, let's point to it. But I find that there are many such that don't appear in the manner like this one. So, Mr. President, speak up. And that is my take. We'll be right back. I'll introduce my guest, and then we'll get into the vexed matters for today.
Well, that's my timetable for the rest of the day.
Oh, that means that you are not going to be around.
So, yeah, and then even next week, the whole of next week, I'll not be around. If there's a way of, if you will not even finish next week, I would appreciate it.
Oh, no, okay, no, I will not finish next week. I don't think I'll be able to finish because the documents are many. So you will surely go and come and meet me.
Oh, no,
but that will also depend upon the judge's behavior.
You can bring one medical excuse next week.
Okay. Okay, fine. If you bring a medical excuse next week.
I said you. How can I bring a medical excuse?
No, you are saying that I should bring a medical excuse next week.
You can if you want.
But brother, you want this one to issue bench warrant for me again? You are not privy to this one, I'm telling you.
In my view, if we agree to this theory, it's so simple, the theory of the case.
Not agree to the way you want to go, the way you want to go about it.
So, let's agree. Let's describe it that way. Let's describe it that way. I want to go about it.
Okay,
fine. Agree this way. For me, it makes it simple.
Yes, it will make it.
It doesn't involve any difficulty for you.
Yes, I agree. I understand your point. That it doesn't.
When you say there's no advancement, yes. When you say there's no advancement, ordinarily meaning in Ghana that you don't pay until you get your goods. Now the contract here, even the clear terms, unless maybe you guys did not draft the contract, it says everything on site of goods shall be established upon the signing of the contract for every future.
No, the contract was drafted by government. It was done by government. And it was an LG department perused the contract and approved the contract for government.
It is not a problem where they approve it. Every contract is actually approved before later when they are implementing it, then problems.
You see, what the difficulty I have with your position is that, you see, frankly speaking, fine, as you are saying, if I agree to your position, how you want to go about it and how you want me to go about my answering questions and things, if I go by that way, frankly speaking, I'll be dishonest because I know that is not how it's supposed to be.
But you want me to go about it your way.
You're welcome back. This is Newsfile, it's almost authoritative news analysis platform, and here on Newsfile we put Ghana first, and this morning we dedicate this program to looking at this very sensitive matter that goes to questions of justice and criminal justice delivery in the country, the Office of the Attorney General, and also whether or not people who are powerful always try not to be situated in the Constitution that says that we are all equal before the law, and find ways and means so they escape prosecution regardless of what wrong they may have done. These will engage our attention, and also the Pwalugu, we fall into the same temptation. I come from the area, and I fall into the same temptation with people when they say Pwalugu. It's Pwalugu Multipurpose Dam, which many of us got really excited about and hope that things will really happen, because our part of the country, my part of the country, the poverty is just too bad, and this would have done a lot of things for this country, but unfortunately it looks like it may be delayed more than time expected. So the matters have become rather very serious as regards the accusations by the third accused person in the ambulance procurement trial involving Ato Forson and Richard Jakpa. There used to be three. Sylvester Anyenini was also one of them, but there was a null proscribed for him, and he was taking off the suit. They are becoming very serious after the allegations that were made, because as we speak, applications are flying left, right, center. At least two applications. One is asking that the charges be struck out. That is, the case should be aborted. Or in the alternative, that the case should be stayed, the proceeding should be stayed against Richard Jakpa. There is another one by Ato Forson also asking for a similar thing, that there's a mistrial. Things must stop because the process is not done in accordance with law. The Attorney General has replied both and uses equally very strong language in his affidavit in the reply to some of these, calling what they are doing a smoke screen, theatrics, and putting together of lies in a stratagem to avoid being tried. This morning, my guests for this discussion right here in the studio are Frank Davis, Chairman, Legal and Constitutional Committee of the New Patriotic Party. He's a lawyer of many years standing at the bar, has been president of the Accra Bar. We used to call him Mugabe. Good morning, sir.
Good morning, sir.
Also here, Sammy Gyamfi is National Communications Officer, the National Democratic Congress, NDC. He's also a lawyer. We may also be joined by Kweku Ansah Sari, former director, Ghana School of Law and legal practitioner. He has views, says the Attorney General should be sacked or he should resign. Joining us also by Zoom is Kweku Pencil, Yamua Pencil. He is a lawyer, also with many years of practice at the bar. He holds a different view to Kweku Ansah Sari and Professor Kujapi. He says absolutely nothing has been done wrong. The Attorney General has done absolutely nothing wrong. He is actually surprised that there is what he calls noise over this issue, because it shouldn't be a matter for any debate, taking so much of our attention. In the second segment, Professor David Miller, former Pro-Vice Chancellor for the UDS and President of the Miller Open University in Bogatanga, will join us. Dr. Charles Nyaba. Dr. Charles Nyaba. Once again, I fall for the anglicization of some of these names, and I say Charles Nyaba. It's Nyaba. Former Executive Director, Peasant Farmers Association of Ghana. And Sammy Gyamfi will remain with us on that subject matter. Gentlemen, good morning and welcome to Newsfile.
Morning.
Right. So let's begin this way, and I will wish that we can go to the specifics and canvass this issue for our audience in a way that does not obfuscate the issues. We are here on this discussion or debate today because on the 23rd of March, 2024, the third accused in the case, Richard Jakpa, was being cross-examined by counsel for the first accused, that is Ato Forson. Then Attorney General A.G. Dami made an intervention that angered Jakpa to say all that he said that has led to all of this. My first question, Kweku Pencil, should the Attorney General have made the intervention he made when he was not the one cross-examining?
What's the specific intervention that we're talking about? Hello?
Richard Jakpa was under cross-examination by counsel for first accused.
Yes.
And then, as he spoke, he said things the Attorney General was unhappy about. Mm-hmm. So the Attorney General made a comment, which comment suggested that Richard was at the trial to sort of do the bidding of the first accused. That's what Richard took exception to, and began to reply him by saying that he has met him several times at odd places and so on. Questioning, should the Attorney General have made that intervention?
No, cross-examination is at large, and therefore, it cannot be limited as long as the question is relevant to the proceedings before the court. So if the Attorney General asks questions by way of cross-examination...
No, Kweku Pencil. It was not the Attorney General who was cross-examined. It's not time for the Attorney General yet to cross-examine. The cross-examination was being done by counsel for the first accused, not the state.
The counsel for the first accused was cross-examining
the third accused.
Whoa. No, the Attorney General is part of the trial. And therefore, within the context that we are speaking, he has a right to object to any question or any answer which a party is given as part of the trial. And therefore, as a matter of law, the question or any cross-examination or any intervention was proper. At the end of the day, it's for the judge, as part of the summing up of the case, to determine the propriety of any question that is asked, whether of the party's own witness or somebody else's witnesses. But at the point that the Attorney General made an objection, he was entitled to raise any objection which the judge, of course, at the end of the day, has to rule upon. So I wouldn't find anything wrong for an intervention. So
let's get the issues in the clearer perspectives for those who don't appear to appreciate exactly what happened in the courtroom.
Yes.
The Attorney General did not raise an objection.
Yes.
Did not raise an objection to the cross-examination, but to the comments, the testimony of the witness when the first accused counsel was cross-examining him.
Yes, Adam.
Oh,
hello?
Yes, you're on.
Hello. Yeah, at the end of the day, the trial was going on. Correct. And as you said, the question was being put by counsel to a witness. And whatever the witness says, the trial involves all the parties. So if the Attorney General has any reason to raise an objection, I don't know how we can call it. But if the Attorney General expressed his displeasure with the answer that the witness had given, that's as good as an objection. In other words, he wanted the court to caution itself either to exclude that particular evidence that was being led as whether relevant or irrelevant. So with due respect, it's not a particular name we give to the intervention. I would put it, properly speaking, as a form of objection that the Attorney General raised to the answer that was given by the witness. In other words, the idea was that the judge would act on his objection and properly exclude that evidence. That would be the only reason why the Attorney General will intervene in the manner that he did.
Right. So the Attorney General, being part of the trial, even though he's not the one cross-examining the witness at the time, was entitled to make an intervention by way of an objection to an answer that the witness was giving at the time, correct?
Quite naturally.
Thank you.
Naturally, yes, that's yes.
Yeah, you have explained. I just wanted you to confirm.
Yeah. Parties, and therefore, there's no special time that will be given to the Attorney General to raise any issue which concerns the entire trial before one judge. So that's, in my honest view, the right and the proper way for the Attorney General to have intervened at the point that he did.
Right. Thank you. Hold it there for me. Sami Jemfi, do you confirm that whilst the witness or the accused person was giving testimony, the Attorney General as the prosecutor, even though not the one cross-examining, was entitled to raise an objection as to the propriety of the question?
All right. My answer is an emphatic yes. Because the rules of evidence are very clear. If you check Section 6 of the Evidence Act, and you read that together with Section 52, a party in a matter who is affected by evidence being offered in court has a right to object to that evidence timeously. The law says at the time the evidence is being offered. Now, if you read that together with Section 52, Section 52 says that if any evidence is offered, even if admissible, but that evidence can unfairly prejudice a party in the case, that evidence, the court has the discretion to exclude that evidence. Okay?
Right.
Now, the question here is what evidence of Mr. Jakpa was objected to?
Right.
And what evidence was not objected to? Now, if you check, I have here the certified true copy.
Yeah, this is what he said, my lady, I have a little difficulty. I think that the question bordering on pre-shipment inspection were asked in cross-examination at the last adjourned date, just for the sake of efficient time management.
Yeah.
This is how it started.
So counsel for first accused, our own brother, Edugita Maklo, if you read from page 24 of the record of proceedings,
right,
and there's a certified true copy, he has shown Mr. Jakpa Exhibit B2. Now, Exhibit B2 is a letter written by Honorable Ato Forson to the Controller and Accountant General for certain funds to be released for the establishment of letters of credit. So he showed him Exhibit B2 and asked the witness whether he could see a security seal on it. And the witness answered in the affirmative. And he began to question him on the effect of that seal. Because the whole case of the Attorney General against Honorable Ato Forson is anchored on the allegation that he had no cause or authorization to write that letter.
That's exactly right.
Exactly.
So the appropriate intervention was at 25.
Page 25.
Where he says, my lady, I'm a little bit constrained to intervene because the Minister of Finance at that time was in court and testified about the authorization. Yeah. I wonder what Mr. Jakpa's business is to testify about authorization.
Exactly. Then if you go on to page 27, the Attorney General says that, my lady, the point I'm making is actually part of my objection.
Correct.
So to put it beyond doubt that he was objecting. And he indicated that he was objecting both to the question and the answer. That it is not in Jakpa's place to testify about a seal on a letter first accused wrote and whether that amounted to authorization.
So you hold on there. Hold on there. I want to do something.
Okay.
Hold on there. I know the comments that came that led Jakpa to say he got angry.
Yes.
Frank Davis, you will confirm as the senior, my senior, not your senior, I suppose, and then Sami Jemfi have both confirmed that the AG was entitled and had a right to make the intervention, correct?
Definitely.
He was entitled.
Definitely.
So nothing wrong was done.
Definitely. Even if it was not by way of a formal objection. Of course, I train lawyers at the bar. You should know, Samson. If you get animated by an answer preferred by a witness, instantly, as a trained lawyer, it comes with you. You are inclined to make a retort or make a comment. Of course, if it's even not a formal objection, we call them off-the-bar comments. You can invite a displeasure of the judge.
That's right.
The judge could caution you that, look, Mr. Davis, if you want to object properly. Don't make side comments. So it comes with the trade. So I really don't see anything offensive. But like Sami rightly has laid bare from the record, he was making an intervention by way of an objection. So
great.
I think it's proper.
So for our viewers, there's one thing. 3 lawyers across the board have confirmed that the AG did nothing wrong in making the intervention he made. So what brought us here? Now let's begin with you.
After he made, clearly the judge did not give any formal ruling on that objection. But you can see from the sequence of the events that the judge, in effect, overruled the objection because no ruling was made disallowing the question or the answer. And at some point, the testimony of Jakpa that ensued after that objection was ordered by the court to be captured in the records.
That's correct.
Now, this is the key thing. After this, then Mr. Jakpa continues his testimony and now says under oath on page 28 to 29 of the record of proceedings that, my lady, I have heard that, but I want to make it clear here that the Attorney General has on several occasions had meetings with me privately at odd hours, both in person and on phone, in respect of this case, to cooperate or answer questions in a manner that will make his case better against A1, Ato Forson. And I have refused, and I have evidence to that. And so if he is accusing me here that I am here to defend A1, which is Ato Forson, he has brought hostilities to my doorstep, and I am responding to the hostilities. And if he continues on this angle, I will open the Pandora's box, and we will all know actually what transpired. He has brought it up, and I will give it to him. Mr. Jakpa continues that, no, he continues on and on. I don't have to belabor the point. We all know what he said. Now, this Attorney General, who was quick, moments before this, to object to a question and an answer from Mr. Jakpa on authorization, the effect of a seal on a letter, very instructively could not object to this answer.
Did not or could not?
He did not, because the law allowed him to object, but he did not. The question is, why didn't he contest this? Why was he, few minutes before then, willing to contest a question asked by counsel for first accused and an answer by this same Mr. Jakpa on the issue of authorization? But when evidence about his personal, conduct, which clearly, per the laws, as we all know, is both unprofessional and criminal, when that evidence was offered, he could not utter a word.
Is it possible that he took the view that these comments coming out of an outburst, someone who is angry, have no bearing on the substantive case?
If it has no bearing on the substantive case, then the right thing any lawyer would do under Section 52 is to apply to the court for it to be excluded. Especially when the court said it should be captured on record.
Is it also possible?
Captured on record.
Is it
and that
also,
is contained on
is it also possible that at the beginning you said you heard him say, I am constrained to intervene?
Yes.
So he doesn't want to do it further to appear to be distracting and disturbing, and disturbing the process.
Okay.
Because when Eduji finishes cross-examining Jakpa, he, AG, will have the opportunity of cross-examining Jakpa. So when he gets the opportunity, then you will take him on. Is it possible?
That is very possible. But the question is this. Until that evidence is uncontested, it stands in the record as uncontested. That is the point I'm making. He had the right either to object to it at that point and ask for it to be excluded, or to wait till cross-examination to undermine that evidence.
Right.
He didn't exercise
hold on,
right
hold on
under
for
the
a
first
minute.
leg.
Hold on for a minute.
And so if I can just conclude in one
to
line
where
on
you
that.
guys want to go to. Yes.
So for me, once the AG himself was in court and in his presence, this evidence was given under oath, and he could not contest it or ask for it to be excluded, it gives me every indication that he didn't have a defense to it.
Thank you.
And
I'm coming to your two other, panelists, and to get something across. The media publications have been that AG was accused on oath and he could not reply. Therefore, he is guilty. What do you say?
Myself?
Yes.
You see, I want us to do this thing in a very professional manner.
Sure, that's what we are doing.
We are trained lawyers, so we should just be guided by what we were taught in school. If a witness has mounted the box and is proffering evidence, that witness is the witness of the court, not any lawyer. So when a witness is given evidence in court, it is up to the judge to direct the evidence that is taken. So whatever comments any lawyer makes in and out of the proceedings is immaterial, because the judge is the reservoir of the facts and the law, the evidence. Okay. Jakpa is proffering evidence. The AG sought to make an intervention and caution himself by saying he was constrained, meaning ordinarily he wouldn't have made that intervention. But because of the animated nature of the evidence coming, it comes with you naturally as a lawyer. He made that remark. Now, as to whether what Jakpa said is uncontested or not, it is not for Sami, myself, or your good self to make. It is up to the judge. But at the point that Jakpa offered that piece of evidence, the AG couldn't have objected. Because that is his evidence. You can't object to evidence being proffered by a witness. It is not your evidence. It is his evidence. So the AG could not have objected. The best recourse was for the AG to keep quiet and have his day under cross-examination. Whatever Jakpa has said will be subjected to the test of cross-examination by the AG. So
just a minute. Just a minute. Kweku Pencil, do you confirm what Frank Davis has said as the practice that we are familiar with? That you are the lawyer, a witness is giving testimony, you do not have the opportunity of replying the witness. Your opportunity is when you take your turn to cross-examine, then you put that testimony through fire. Correct?
I agree with my learned senior Frank Davis, and I would like to add to that by saying that litigation essentially is tactical. Whether to ask a question, ask a question of a witness of something that he has said there and then or subsequently. In this particular case, it has not even reached the time of the Attorney General. It has not reached, and therefore the trial was not over. And the reason why the Attorney General, indeed and in fact, with due respect, it is my personal view that in the context of the trial itself, that evidence, in my honest view, was irrelevant. It had no bearing whatsoever on the matter that was being tried. The fact that an incident transpired in the course of the suit, which a party knew but never put it in his witness statement or did not make an issue of it, but got angry during cross-examination on the basis of his anger or his response, says something which was not before the court, does not make it a relevant issue for the court at all. And therefore, even if the Attorney General decided in the scheme of things never even to ask a question on that issue, personally, I wouldn't know and I wouldn't see how that retort by the witness in the box was going to affect the outcome of the case one way or the other. Because I've never seen, with due respect, I've limited knowledge of all the factual evidence before the court. But I've never heard anywhere that the witness statement of Jakpa or any of them rely on a live meeting between him and the Attorney General. I don't know, but if that evidence was not before the court, the mere introduction of that evidence at the stage that he claimed that Attorney General was annoying him or whatever, I personally would not see how, at the end of it, if I summon up the case, you can introduce that to sway the judge or to persuade the judge or to make the judge believe that something that transpired out of the court has any influence on the outcome of the case.
You are not saying, and this is a point you have made over time in the week. You are not saying that the conduct of the courts, counsel, or parties, or witnesses, any misconduct that could impact on the fairness of the trial could result in a mistrial. You are not saying that cannot happen?
No, in the absence. You see, you can raise an issue of mistrial by a formal application where the entire evidence...
No, I mean when you said it's irrelevant, it does not impact on the case. It does impact on the case, correct?
So the exchange of that day at the point that this incident took place, I wouldn't know how the judge can take that into consideration in the assessment of the evidence before the court, when that did not even form part of any party's case before the court.
All right.
I wouldn't know.
Okay. So now hold on. Now let's now move in this direction.
I have something to say about this one. If you can just allow me.
I want us to go to the tape.
We'll go to the tape, but let me
then begin to talk about the questions on the tape.
There are two things that I need to say. Number one, Frank Davis and Mr. Pencil are contradicting themselves, and they need to see that contradiction.
How?
Because a few minutes before now, they said that the Attorney General had the right and was actually right in objecting to evidence being given by a witness. Few minutes after, they are saying that he had no right to object to evidence being given by a witness, and that the right thing for him to have done.
It's Pencil who said something close to that.
No, he said
Frank Davis didn't. He didn't.
He said it.
He didn't.
Can go and play the tape.
He spoke about it as a matter of choice.
No. I said it was a matter of choice. They are saying no. Hold on. You see, let's discuss this as professionals. You are saying that the AG, as the prosecutor in chief in this matter, had the right to object to Eduji's question and Jakpa's answer about authorization.
That's correct.
Then when it comes to allegations or evidence about his professional misconduct, okay, you are saying that he didn't have the right to object.
No, that he can adopt a strategy.
No, nobody says.
And the strategy is that he will have his day.
So let's settle it here and now.
Listen to
that it is wrong for anybody to say that the AG didn't have the right or the option to do so.
Thank you. Now let's go here. Let's go here.
Not just that.
No, if we are not careful, we'll go into this banter and not go into the meat.
It's 2 against 1 on this particular one. So
no, it's not 2 against 1. These are Pencil is a lawyer making his submissions. Of course, he's with the MPP, so we can say that.
Let me also say that the fact that a lawyer in a matter may have the right to 2 options, okay, either to object to evidence at the time it is being offered per Section 6 of the Evidence Act, okay, read together with Section 52, or either to wait for his turn to cross-examine and undermine that evidence. The 2 are not mutually exclusive, and the lawyer can do both. And this is the first time such serious evidence will be given against an attorney general of the land.
Okay.
So when they talk about the practice,
thank you.
There is no practice on this.
I can tell you that from the benefit of practice, there are questions I can keep quiet about because I don't want to alert you before I start cross-examining you.
Yeah. So you
I don't want to alert you. I want you to get, when it gets to my time, then I put you under.
So why didn't you do that on the issue of authorization?
Right, so let's move here.
Why didn't
I didn't want you to come in. That's why I wanted to close it.
That on the issue of
okay, do this quick and let's go. Quick.
With great respect, I don't contradict myself.
All right.
So don't put contradiction in my mouth.
Right.
If you listen to me carefully, you appreciate what I said. I never contradicted myself. And that has been pointed.
Viewers,
thank you. So now let's go here.
Never contradicted.
Let's go here.
Listen to me.
Let's go here now. We have taken care of 2 major issues, and we are going to unpack it in this manner for you to appreciate. Follow us because this is law. We can't do it any other way. Now, the Attorney General made no mistake in the intervention, number 1. He made no wrong. He did not breach any law. Number 2, that he did not reply. In fact, he did not have the right of reply. He can cross-examine the party on it. He can also object to what he said. But it is also a legal strategy for a lawyer to decide that instead of objecting, I will wait when it gets to my turn and I use the same information against you. So we have settled that. The fact that he did not reply doesn't mean he's guilty. Now let's come here. In the tape, the AG is seeking cooperation of the accused contrary to the AG's public statement, paragraph 2. Kweku Pencil, do you agree or you do not agree?
When parties meet to do what we call a settlement or plea bargain, everything is allowed between the parties, subject to the overriding concern that it is that discussion, once it is in camera, it is not for the public consumption. It is a trading. The parties, and therefore, it is in absolute bad faith. Because, see, what is happening is that we've got a party who attended the meeting with a mind to record the meeting. Be very careful about every statement that he makes, whilst at the same time giving an impression to the other party that we are trying to settle this case and we are doing a trading, and of course allow the Attorney General to say everything that he needed to say. I find absolutely nothing wrong with anything that the Attorney General said within the context of a settlement.
Okay.
Because it was a trading.
Mr. Pencil,
yes.
Mr. Pencil, this is the question I'm asking you. It's a direct question, and I'm picking it from the AG's statement. In paragraph 2 of the AG statement issued on the 23rd of May, 2024, It reads.
Yes, I'm listening.
It reads, the Republic has never required or desired the cooperation of any of the accused persons in this matter, in which it has already succeeded in establishing a prima facie case against all the accused persons. Operating phrase, has never required or desired the cooperation. I'm asking you, from the tape you have heard, the AG in that conversation is seeking the cooperation of Jakpa, contrary to what they say in the statement, not so?
I agree with you, but I will repeat that insofar as that discussion was heard in a without prejudice context, it is in absolute bad faith that one party attends a meeting with the knowledge to report a without prejudice discussion and then turn it into the public domain. So therefore, the judgment that the public must properly be making is not that statement on its own, but within the context. Because forget about what I told you.
Did we lose Koku Pencil?
Of the day, it's not very much what I told you I said, but I am compelled to say what I'm saying by reason of the fact that the statement which is being put to the public for assessment or being put to me for my
we are losing you. We are listening to you once in a while as you speak. Hello, Koku Pencil. Okay, so hello.
Within context, yes.
We are having a challenge with your line, but I needed you, if you can do this in a minute for me. You confirm that from the tape you have listened, the AG was seeking the cooperation of the accused. That's what your confirmation is.
That is so.
And the AG issues a statement and says they have never required or desired the cooperation of the accused. What do you say about that?
I'll put it in the same context that within the court trial, the trial which is in court, they've never, but in an out-of-court settlement or in a purported attempt to settle the matter of court, there's nothing wrong if you sought the cooperation of any of the parties to compromise the case. A normal practice in our legal profession, which is guided by law.
Okay, so we'll get there as that issue also, because that's the thrust of all of this, whether the AG was doing something wrong and the accused person had a lawyer or had no lawyer. Sammy?
Well, it's very sad that Mr. Koku Pencil will seek to mislead the public in this manner. Now, number one, Samson, you refer to a tape recording, which is a recording of a telephone conversation, not a meeting. So this issue about plea, bargain, negotiations, or meeting is neither here nor there. That call was a call placed to Mr. Jakpa on the morning of 9th April 2024, a day he was supposed to appear in court to testify. It could not have been a plea bargain negotiation. Because number one, the Plea Bargain Act, Act 1079, is clear. Plea bargaining can only be done with a represented party through his lawyers. On the 9th of April 2024, Mr. Jakpa was represented by the respected lawyer Tadio Sori. He could not have been having that conversation with a represented party and call it plea bargaining. Again, the Plea Bargaining Act is very clear.
The spokesperson for the Attorney General has said that Mr. Jakpa was not represented at the time of the conversation.
Which is a lie. Because the conversation, we've shown you the WhatsApp record, was on the 9th of April 2024. And on 9th of April 2024, go and check the court records. Tadio Sori was lawyer for Mr. Jakpa. So another lie. Okay, so this has got nothing to do with plea bargain. In fact, if you read the Plea Bargain Act, before you even begin plea bargain negotiations, the court has to be formally notified. And that requirement is mandatory. It says, shall notify the court. And an adjournment given for that purpose. Now,
I can agree with the other party before the court gets to become aware, and then we just tender the settlement terms before the court. The court will adopt it. The court will not say because we didn't notify it, it will not accept it.
But then can you agree with that party without his lawyer? Will you do that, Samson, per your training?
The law prohibits it.
Exactly. Rule 56(2)(d) of LI 2423 is clear. A prosecutor cannot confer with or interview an accused person. Open and shut. A prosecutor cannot confer with or interview an accused person. Rule 13 of the same LI 2423. And for those who don't know, this is the Legal Profession, Professional and Etiquette Rules 2020, LI 2423. Rule 13 is clear that a lawyer cannot communicate with a represented party directly.
Rule 13 says,
yes,
a lawyer shall not approach, communicate, first approach, communicate, or deal with a represented person on a matter, or attempt to negotiate or compromise a matter directly with a represented person, except through or with the consent of the lawyer of that represented person.
So when Mr. Kwaku says that per the practice, this is normal, that conversation, what is he talking about? Has he addressed his mind to this rule? This is Rule 13. Let me read to you Rule 56.
His major concern, as I understand him, is that this is a without prejudice conversation. And a without prejudice conversation ought not be put in public because it cannot even be admitted in the court.
It is only a plea bargain conversation which is without prejudice. I have demonstrated to you that this was not a plea bargain conversation. All the requests for plea bargain from the letter of 27th April to Jakpa's letter of 16th May to his 30th May letter and the 12th of June letters, according to the AG, were all rejected by him. So, according to the AG himself, he has not had any plea bargain negotiations with Mr. Jakpa. We are talking about a telephone conversation on 9th April 2024. Yeah, that's what we are talking about here. A day the witness was supposed to go to court to testify. How can you be having plea negotiations on a morning of testimony day? No, the same morning, the same day. And Rule 56, 2D is clear. A prosecutor shall not confer with or interview an accused person. You understand? So by calling the accused person and coaching him, persuading him to give testimony not based on matters within his personal knowledge, but within the knowledge of the AG, and to skew his answers in such a way that supports the AG's case, because the AG kept on saying in the tape that those answers will create no difficulty for him if he did so. And even when the witness was saying, I can't do this because I will be dishonest and I will be implicating an innocent man, the AG was still hell-bent on pushing him to do that. He breached Rule 13, he breached Rule 56 2D, he breached Rule 54 because he was telling a witness to give testimony that in the knowledge of the witness was false. And what is even worse is that he breached Section 213 and 214 of the Criminal and Other Offences Act, Act 29, by telling a witness to forge a fake medical excuse duty to deceive a court, which is the crime of perjury, second-degree felony. Now, to conclude, just one sentence to conclude. This is very clear, and Mr. Kwaku Pensel respectfully has admitted that what the AG said in his press release of 23rd May 2024 to the public, that he has never sought the cooperation of any of the accused persons, was a barefaced lie. And that demonstrates the lack of integrity, the lack of character of Bisa Godfrey Diabuadame, the more reason why he must be sacked now.
So Sami Jamfi has quoted a number of provisions, including the Criminal Offences Act. He refers to Section 213. Section 213 reads, fabrication of evidence. Whoever fabricates evidence with intent to defeat, obstruct, or pervert the course of justice in any proceeding shall be liable to the same penalties as if he had committed perjury in that proceedings. And perjury in this circumstance is a second-degree felony, attracting up to 10 years in jail. He has referred to various rules of our professional code of conduct, among which the provisions he refers to, one of them here says, a lawyer shall not coach or encourage a witness to give evidence which that witness believes to be false. Then he refers to one which I have read earlier. All of these, what do you say to that position that he takes?
Before I do that, Samson, I would rather we are temperate with language. I would rather we are temperate with language.
We should.
It's a discussion. Ghanaians are all discerning, they are listening. So
I agree with you.
I would rather advise my brother to temper the language. I mean, sometimes it's a bit too harsh. I mean, we are trained lawyers. I mean, even if you have a disagreement with someone, the language should be elegant. This oft-repeated beating of integrity and all that, I think we should reserve it for those who don't understand our training. I'll beg of Sami, he should not indulge himself too much in that. It doesn't do justice to our practice, with all due respect to you, please. Now, I don't want to be a lawyer and a judge in my own cause, as he is doing. This repeated recitals of sections 13, 52, 54, does nothing to the conversation we are having. I have said from the get-go, it's left to others to disagree with me, but I have said from the get-go that that tape is doctored. So I really do not want to place too much premium on what transpired on that tape. In any event, nobody can tell anyone in this country the circumstances under which that conversation took place. They are saying it was a day before the court, whatever. But if you listen carefully to that conversation, it's a pieced up document. Because you never really would hear currently what somebody has said. It is only Jakpa's voice which is always heightened, and you hear him speaking. Now, I listened to that tape recording. I cannot, for the life of myself, see at what instance I heard the AG coaching. I'm choosing his words. Coaching, persuading, and getting Jakpa to skew evidence. You clearly can discern from what was going on that they had a disagreement over basic understandings of what was transpiring.
The LC.
Yes. They had a basic disagreement. Now, this person says this other person says this. At a point in time, I think the AG said, okay, you can say what you want to say. That is when...
that if you do it my way, it will not create any difficulty for you.
And then the guy said, Jakpa said, I will not do it your way. Because if I do it that way, I'll come out as dishonest. And I will not be doing fidelity to the proceedings. Fine. How can this be one of coaching? I'm having a conversation with you. You say something. I also say something. We disagree on it. You stick your path, I stick my path. How can that be coaching?
Could it be a failed attempt?
It cannot be a failed attempt.
Because if he had agreed, then he would have done it the way the AG wanted. Okay.
He didn't agree. That's the bottom line. He didn't agree. And you see, let us take all these things into context. I still maintain, like you said, that this is a without prejudice conversation. Whether the AG was right to have called Jakpa, or Jakpa was also right to have picked up the AG's call, is another matter. When we get to that bridge obviously will be crossed.
In law, when we say without prejudice conversation, what do we mean? Educate our viewers.
Without prejudice means whatever we are saying, we are not bound by it. So you say what you want to say, I say mine. But no one is bound by what we are saying.
And that communication cannot be used in the court of law.
That is it. That communication cannot be used because it's without prejudice. So you see, this attempt, you see, and let us be cautious the way we push this thing. In the first place, the intent, they are talking about criminal conduct of the AG. Sami JV, it's criminal conduct of the AG. But he thinks that as a trained lawyer, the intent of Jakpa to have a conversation with someone and secretly tape that conversation without the consent of the other party, that to Sami JV is fair. That to him is not criminal conduct.
So
that's clear evasion of privacy.
So by our constitution
Yes.
in Article 18.2,
Yes.
you cannot do that. You are not allowed to interfere with someone's privacy or privacy of the property or their communication. But you see that there are exceptions, including for prevention of crime. If their view is that this is to stop the perversion of justice and that perjury was being committed, that is a crime. So then, wouldn't they be justified in saying, in this instance, the without prejudice will not apply?
Why?
Because
Why?
of the exception.
What is the exception here?
That it is to prevent crime.
Which crime? No, which is the crime you are alluding to? The Attorney General calling him?
He says section 213.
Fabrication of evidence.
Exactly.
Why was Jakpa going to fabricate evidence? If I disagree with you, if we are to explain what letters of credit is,
Right.
you have your interpretation, I have my interpretation, and you stick to your interpretation. Can that be fabrication? Under what context can you call that fabrication? You see, if we are not careful enough, we are going to mix up this whole thing with people shouting and not understanding what they're saying. I come from a background of a trained lawyer, so I speak as a trained lawyer.
All right.
I'm not given to what media men or what people who are illiterate in the law will do. I stick to my training. I don't see any fabrication of it unless you see one. I have a basic understanding of something. You have yours. You stick to yours, I stick to mine. How can that be fabrication?
Okay. So when I started this show,
Yes.
I did Samson's Stake.
Yes.
And I was talking about how in 2016, for example, I have many, many friends in the NPP. And they will share messages, they will share documents like Samuel Kujeto will do today. And then we'll say, this is wrong, this is bad, let's do stories, let's do news about it. Coming to a question. Imagine this had happened to an attorney general in an NDC regime, and I called you on Newsfile. Would you say you see absolutely nothing wrong with it, just like Kuku Pencil also believes?
Samson, it is only when you don't understand the basics of our training that you will be quick to judging people. I mean, in all humility, you have followed my practice for some time.
Sure.
You have spoken to me on very topical matters.
Sure.
You'll be the best judge. I don't boast about what I do, but it is for Ghanaians to judge me. If it had happened in the NDC era, I would maintain the same stance I'm maintaining now. The Attorney General, for whatever we say about him, is the leader of our bar at any particular point in time. The Attorney General is the Attorney General.
All right.
We can have people bash him. For those of us who train under him, if he's the leader of our bar, we train under him. I'm using this figuratively. So if the Attorney General in the NDC time is the Attorney General, the Attorney General in the NPP time is the Attorney General, I will have maintained the same stance. Because you see, we should not bring ourselves into conflict at all with the law. That because we want to parade a certain line, we will bastardize what our training stands for. If an AG in NDC's time had fallen into the same trap, I'll have maintained my stance.
All right. Kwaku Pencil, hold on. Kwaku Pencil, earlier, you were of the view that there was absolutely nothing wrong with this, particularly because you were under the belief that the accused person was not represented. Coming to know that the accused person was represented, does it change your view that absolutely nothing wrong was done?
See, let me put it this way. I know where you want to get me to, but let me put it this way. The laws that Sami Jefi quoted is the law on the subject. The context within which these meetings took place or didn't take place is a question of evidence. So therefore, questions can be answered on the basis of certain assumptions. Because if my understanding is right, 73 himself is a lawyer with the active conduct of the case in court. I got that impression. I don't know whether that's a fact.
No, he's
but
not.
I got the impression. He's what?
He's not. He's not a lawyer in the matter.
Well, if he's not, I wouldn't know the circumstances or the context within which he got into trouble with the trial judge. But
because of his public comments.
He's not the lawyer in the matter.
Well, if his public comments, I think he needs to be more careful in his public comments by reason of the fact that he's a lawyer. But the question that you asked me is a pointed one. And we must be very careful on issues like this in the media, not to make judgmental or be judgmental about the things that we see. So I will answer your question that if there's clear evidence that at all material times of this conversation, the gentleman was represented by a lawyer, and then the law is very clear that in those contexts, the conversation must take place with a lawyer, and the Attorney General with that knowledge did not do. We don't even know who called who. But let me put it that way. I want to be as honest as I can. That it can give rise to an issue that borders on the ethical conduct of the Attorney General, which ought to be discussed outside the courtroom. Anybody believes that by so doing, allegedly, the Attorney General committed a criminal offense, that is another matter for the court to decide where all the facts and the evidence. So I'm not going to go into a banter as to what exactly.
You said that's another matter for the court to decide. Is the Attorney General is the only one who can institute criminal proceedings in the country, right?
Yes.
So if he's being accused of crime, who will do it?
Only a crime. It gives rise civil consequences before we come. For instance, if we cite the Attorney General for criminal contempt of court, he can't say that he will not defend himself because he's the Attorney General. It can never be the case. And of course, I appreciate the position of the Attorney General in commencing all criminal proceedings in this country. And therefore, I can find the difficulty if one prefer criminal charges against the Attorney General. But let nobody think or believe or suspect or somehow, come to the conclusion that the Attorney General, if his conduct in the circumstances is not right, the only way to tackle the issue is by, preferred criminal charges against him. It can never be the case. And that is why, personally, I think and I believe that the attempt to comment on the Attorney General's conduct within the context of an ongoing trial is even relevant. I don't see it. Because the court relies on the evidence that comes before it. And the fact that the Attorney General made this conversation with an accused person, right or wrong, will not, in my honest view, impact the trial of this case either left or right. In other words, if it is true, as we are made to believe, that he had this conversation with Jakpa and he expressed a view as to whether there is a case against him or not, that is irrelevant in my honest view. And the matter before the court will be tried on the facts and the evidence. So the expression of an opinion to the same person that there may not be a matter before, there may be a case against you, is, in my honest view, not a reason for the present application. But I need to question myself because there's an active trial going on.
Right.
There's an active trial going on. And if we are not careful, we will descend into the merit of a matter.
Yes, when you say what you say, you go back to your position that this does not impact on the trial. Now, I was pointing to you that the factors that lead to a mistrial include the conduct of the prosecutor.
Not the conduct of the prosecutor in a general sense. In other words, as impact the issues before the court. A mistrial is a mistrial when you can demonstrate that without evidence, I'm not just one, I'm not giving a general list, that there's no evidence against the accused person, but nonetheless, evidence has been manufactured or something. You can point out the manufactured evidence before the court. Now, the only thing, with due respect, that they are saying is that the Attorney General confers to the witness that, not the witness, I'm talking about the accused person that after there's no case against him, does it negate the facts and the evidence that have been filed in the witness statement before the court? And don't forget that this whole conversation was done within the context of what we call a settlement listing. In other words, for purposes of reaching a conclusion.
On the issue of purposes of reaching a conclusion, as in plea negotiation, if you follow the timelines, the date lines of the process, you may have a different view. The Attorney General says in paragraph 3 of its statement, which we referenced earlier, that what they were doing was in furtherance of plea negotiation. They refer to letters of the 27th April 2023, 16th May 2023, 30th May 2023, and 12th June 2023. As we understand by the Attorney General, it says this plea bargaining proposal has to date not been accepted by the Attorney General. As we understand, the Attorney General says it rejected the plea offer. How do you situate that in continued conversation on a plea bargain process which has been rejected, actually after the submission of no case has happened and the witness, the accused, has gone into the box, opening their defense?
I'll put it this way. Even at a trial, even at the end of the trial, there can always be a settlement, even at the end of a trial. So that pre-trial settlement or trial settlement in the court, it's a continuum. It's something that starts and never ends as long as either party is desirous of going back to the drawing board. So there's no particular time that anybody can say, except that the rules must be followed. And I'm even assuming for the purpose of our conversation that if it became an issue, for instance, that on this particular date, when the Attorney General spoke with this witness, his lawyer was not aware. I really have no doubt if the witness did not inform his lawyer about that conversation, and if he did not inform him, why he didn't inform him, because he came with a recorded or whatever on phone, he still have the opportunity to record what transpired between the two of them. And I'm really wondering why you were to come into the witness box and begin by certain answers to kind of threaten the Attorney General of something against you and whatever. Was it blackmail or what kind of practice would that be? So you see, I'm making the point very clear that if you have a case against somebody, you don't wait for the person to do something, then you wait, then you also hit back and that kind of thing. So it raises lots and lots and lots of suspicion about the context in which this whole matter is being discussed. But the point I'm making is simply that aspect of the matter is currently before a court of law. In other words, the judge, if my understanding is right, an application has been brought before the court for the court to terminate the trial on
two
the
applications
basis of
two
these
applications
things that transpired outside the court.
All right.
Two applications.
Okay.
And for the judge to make an assessment of the evidence contained. Yes, and that's my view of the matter.
All right. So hold on.
I want to express my view.
Hold on there. Hold on there. I'll come back to you. Hold on there. I'm getting complaints that I'm giving you too much time. So yes. What do you say about the facts of a continuation of a plea negotiation? Right. And you know in law that the plea negotiation can continue for as long as there's no judgment. Okay. And Ato Forson, it was the day the judgment was about to be delivered that he intervened and it was stopped. What would you say?
So plea bargaining is done on phone with a represented party without his lawyer. Plea bargaining involves telling an accused person you are prosecuting to forge a medical excuse duty. Plea bargaining includes telling a witness who by law is supposed to testify to matters he perceives, matters he knows to be true, persuading him to testify to matters that you think, you, an adversary, think to be the truth. Is that plea bargaining? You see, there's been a lot of talk about, let's talk in line with our training as lawyers. But what is actually being done on this platform is that the law and the training we've been given as lawyers is being turned upside down. This is the apogee of intellectual dishonesty.
I haven't
seen the things on the table. What has that got to do with plea bargaining? And we don't know what the plea bargaining law actually talks about. I've not mentioned anybody. I've not mentioned you, my brother. I've not mentioned you. Let the viewers judge. And you will realize that I've not interjected or echoed your words.
Hold on for a minute. Hold on for a minute.
You're going to distort my thoughts.
Sammy, hold on.
Write what you want.
No.
Keep your thought.
When you were talking,
I will not.
You even made personal
I will not sit here
against my person.
I didn't say anything.
And I wrote them down. I didn't
say anything against your person.
So you're going to show me the same respect.
Please. I've shown
and you're going to allow me to also make my point. So take your pen and your paper.
I've shown you.
Write the comments I'm making which you disagree with. But I will make my point.
I've showed you.
If something allows you to interject,
I have showed you.
Then I must also be allowed to interject when you speak.
I have showed you.
So then allow me to make my point. Allow me to make my point.
Hold on for a minute. Hold on for a minute.
This show has rules. Allow the rules to work.
I have showed you so much respect.
Please, let me make my point.
Sammy, wait, just a minute. Just a minute.
I don't intend that.
If you allow this, then you're going to allow me to interject.
I don't intend that you came here with an attitude to disrespect me. Because I have never disrespected you here.
What have I said here?
Please. You said I made comments against your person. I have never made any comment against your person.
All right.
Please.
Okay.
All right.
Thank you.
You see, if Sammy Jemfi is making a point, there are 3 discussants. Myself, him, and Kuku Pencil. I have never, throughout the transcript of this proceeding, said anything about plea bargain. So if he is talking in the context of plea bargain, he should situate it to Kuku Pencil. He should not use general words to describe all of us.
That's a fair point.
Okay.
Sammy,
Two things. Let me just respond. Number one, he says he has not spoken about me. He has. When he suggested that I have used interpret language.
Can we progress without this?
Samson, allow me to talk, because you see, there are 2 people who are ad idem on this subject. They've had ample time to speak. Allow me to also make my point respectfully.
So progress on the substantive.
On the substantive point is that when he suggested that I was using interpret language, it was unfair because I have not. And as a lawyer, per his training, he knows that if I build my case and on the basis of that say that case shows a lack of integrity on the part of the Attorney General, that is not interpret language.
His objection
now, let's go on.
The question of intellectual dishonesty on this platform.
Lawyers don't even say intellectual dishonesty in court.
On the question of plea bargaining, which he has not spoken to. So it's fair.
Oh, I will tell you.
Now go on.
Okay.
No, Sammy, go on.
Yes, I am going on.
Sorry, let's allow him.
The intellectual dishonesty in respect to him is about his use of the phrase that conversation we are talking about, the tape, was a without prejudice conversation. A telephone call conversation is not without prejudice. This is trite. And so, as a senior lawyer at the bar, you cannot suggest on a public platform like this, arguably the biggest platform in this country, that a telephone call conversation
let's not stay
between
there.
The Attorney General and a representative.
So go to your substantive point, then it will get to him. Yes.
Number one. They say that the tape we are talking about, Mr. Davis says that it is doctored. As a lawyer, he knows the law governing the issue of doctored tapes. The case of Kennedy Japan versus Anas is clear. If you want me to read, I'll read that to you. Even in the submission or the ruling of this trial court on the application for submission for no case answer, the judge lays that law very clearly. That when a person asserts the affirmative and another person asserts the negative, the burden of proof is on the person asserting the negative, the positive, to adduce evidence to support his claim. So if we have put out our tape and we are saying it is not doctored, and you say that it is doctored, the onus is on you to adduce evidence to show the doctrine. So far, you have not adduced a scintilla of evidence to show any doctrine. Again, you don't even have the locus in law to even say the tape is doctored, because what you're saying is total hearsay. You were not on that phone call. The person who was on that phone call is Mr. Dame, who is very vibrant in the media. Neither Mr. Dame or his spokesperson, my good friend Wilberforce, has been able, since we published this tape, he has been able on any media platform to say that the tape was doctored. Neither Mr. Dame or his official spokesperson has been able. The Office of the Attorney General has also not been able to even say that the tape was doctored. So that wishy-washy response is very weak. We can't work with it. Again, he says that the tape is pieced together. So he should tell us which parts of the tape we have heard is pieced together. You don't deny that there was a call. You don't deny that the voice on the call was Mr. Dame. You say that parts have been pieced together. Which part has been pieced together? Show us.
There was a part that was repeated.
Yes.
And I think they referenced that in their press conference
to
show the piecing together.
There is no part of the tape we put out which is repeated. Not even one part. Not even one part. I heard him at this press conference saying that the tape is doctored because we said we will start our press conference at 2 p.m. and we started around 3 p.m. so we were doctoring the tape. This is law. These are the people who say they are trained lawyers and they always speak in accordance with their training.
No, you cannot say that.
Okay, I take that.
You cannot say that.
I take that back.
You cannot say that.
Now, number two. Let me go on. Now, number two.
He's withdrawn it. He's withdrawn it.
Now, number two.
I don't like the way he stretched.
He's withdrawn it.
Because I have more vitriol than he has.
He's withdrawn it.
No, I have
no, don't go there.
It's an opinion. And I respected your opinion.
It's not an opinion. It's wrong. It's wrong.
You cannot
now,
Mr.
Davis, you see,
he has withdrawn it. Sammy,
let's go.
Sammy, please.
Now, he also goes on to say...
He has withdrawn that.
He goes on to say that on the tape, Mr. Dame is not heard coaching or persuading the third accused in any way. And Samson, you yourself, you said it. On the tape, he is urging a position about the effect of letters of credit and what happened in the transaction, in dispute. And he tells the accused person that if you testify the way I want you to testify, if you testify according to my theory, my position, it presents no difficulty for you. It makes the matter simple. He says that repeatedly on the tape. Repeatedly on the tape. In fact, Assassin Radio, which is owned by Gabi Ochredako, they put out a story. And in the story, they attribute quotes to the Attorney General. And if you look at those quotations, they say that at a meeting at the residence of a Supreme Court judge, the Attorney General, they quote him as telling the accused person that I will give you an exhibit, cabinet approval. I will ask you A, B, C, D. Answer yes to this one. Answer no. These are quotations put out by Assassin Radio that Mr. Dame, very vibrant in the media, has not been able to dispute. So in the face of this overwhelming evidence, if you tell us, discerning Ghanaians, that he was not coaching him, he was not conferring with him or persuading him, what are you talking about?
Sammy, you know that as lawyers, we are not experts in everything.
Yes, we are not.
And particularly as we are in general practice, people come with their issue.
Yes.
We take the facts and put the law around it. You hear them discussing the LC.
Yes.
And you can clearly see that the guy is more knowledgeable about the LC than the AG. There's nothing wrong with that.
There's something very wrong with that.
What is it?
Before you go to court and build your prosecution, your case on an LC, you must first of all seek experts' knowledge on what an LC is. It is not when you have already opened your case and closed the case, and an accused person is going to court to testify, that you go to the accused person for education on what an LC is. No lawyer worth his salt does that. When you have already opened your case and closed your case, and now the accused person is going to court, what are you afraid of? That you can't wait for him to come to court and give his testimony. And if you disagree, undermine that testimony in the box, which is what any lawyer, any trained lawyer would do. Now, my brother, again, please. Again, he says that where is the criminal conduct? In the tape you played, even on this show, Mr. Dame is heard telling the third accused to, even though he knew he was very fit, to go and procure a medical excuse duty.
If that were proving, that is misconduct, not crime.
No, that is crime. That is crime because if you check section 213 and 214, fabrication of evidence, and 214, if I can I read 214?
But that will not be evidence.
That is evidence. Medical excuse duty, bringing a medical excuse duty to the court to say that you are sick when you are fit is what?
It's evidence for what?
It is evidence to get the court to adjourn to allow the Attorney General, the prosecutor, to travel. The Attorney General cannot tell the court that give me, an adjournment. He doesn't even trust his deputy and the DPP to take over the case when in his absence. He wants an accused person who is a witness.
But that doesn't contribute to the case. It doesn't contribute to the case. How the judgment will be rendered.
Whether it contributes to the case or not is irrelevant. 213 says, anyone who fabricates evidence to deceive a court is guilty of perjury. And 214 defines what is that deception. It says that if you bring any circumstance to exist that deceives a court, you are guilty of perjury. So by telling him to go for a fake medical excuse duty, he was telling the witness to bring a circumstance to exist in court that would deceive a court. Then finally, my brother, Mr. Pencil keeps on saying that this evidence, even if true, borders on ethical conduct of the AG, it cannot impact. I don't understand this. We are all trained lawyers, again. Don't we all know, Samson, that every accused person has a right to a fair trial? And if the accused person can show evidence that a certain trial is unfair, malicious, that can lead to the termination of the case through an order for mistrial. This, if you look at even the affidavit that has now, the application and affidavit in support of Mr. Jakpa, asking for the termination of the proceedings. Okay. He is telling you that the Attorney General, he has evidence of the Attorney General telling him that he is innocent. He is not a target. He has no case to answer. But that due to pressure from the then finance minister and the president of the republic,
as you can see,
the court will determine that.
As you can see, I was pointing out to Senior Pencil that if there is a possibility that this can impact on the matter in the sense that these applications, if they carried the two applications asking that the matter be, completely terminated, would have meant that it has impacted on the matter. But there's difference in opinion. So let me come to... that was your last point.
Let me just...
You said last, concluding.
I just wanted to reinforce a point that you made. That once evidence is relevant, as lawyers we know, that it matters not how it was procured.
R versus Leighton, even if it is stolen.
Exactly. Thank you. And when it has to do with evidence that borders on a crime against the state.
The question is, evidence for what?
Evidence that shows
that the procurement of the ambulances were correct, that they were not vans fitted with kitchen.
Evidence that shows, evidence that shows that the case of the prosecution is based on nothing. They know that they don't have a case, and yet they have contrived the case. All right. They are contriving evidence, and they are willing to even commit crimes.
Let's come to Frank Davis.
In relation to
let's come to Frank Davis.
The pertinent issues that I think all of us should be.
Thank you. And there has been fingers pointed at Article 296 of the Constitution, which the Attorney General is bound.
Yes.
296 says, where in this Constitution or in any law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process. People point to this and say, if the claims made are true, if what we find in the tape are true, then it means the Attorney General is conducting this in a biased way, not in a candid way, arbitrary way. He's being capricious in the exercise of that discretion. And so that is why the trial cannot go on.
Samson, I will not be tempted to go into the merits of an application which is pending before court in a trial.
I agree with you.
I will not, nobody will push me.
All right.
That is why I've stayed out of this mistrial and this striking out of Plea. Been very quiet listening to maybe Goku Pencil and I'm not going to be, I'm not going to be swayed into getting there. There are two separate applications before the court. The determination will be made in court.
That's right.
I'm not even a lawyer in the matter. I come to sit on radio to discuss applications. I don't do that. That's below my training. I don't do that. Now, let me answer pointedly to what he has said in the last number of minutes. I would appreciate that my friend and brother would listen to me carefully before making some pronouncements. I sit here to educate Ghanaians, not him. So, the context in which I use the without prejudice, he should understand. Without going on radio and saying I'm a lawyer and I should know what. He doesn't know any better than I do.
He withdrew that.
Yes, but you see, the without prejudice comment I made, I said to you, in any event, the conversations on that tape, you can say to some extent is without prejudice. Because they had basic misunderstandings about what the LCs stood for. I am not making a general proposition. So he should situate whatever I say in context. I don't come here to just speak. I think about what I say.
Please don't intervene. Please don't intervene. Don't intervene.
Sammy cannot be without prejudice.
Sammy, please don't intervene. Thank you. You have said that. It's a point you have already made. Thank you.
I don't know.
I said the context in which they spoke about their misunderstanding is without prejudice, because both of them could not hold each other to what the meaning was. He should be prepared to understand and listen. Now, about the doctrine.
Right.
I am not an expert, and I don't profess to be an expert, but I'm an intelligent person. If you claim that there's a 26-minute tape recording between the AG and Jakpa, you said so, I didn't say so. NDC said so, that there's a 26-minute tape, and you play 60 minutes of that tape. Where is the other 10 minutes?
It's possible you recorded only 16 minutes.
No.
They said there was a 26-minute conversation.
Conversation, yes.
Which he recorded.
Yes.
Which they are playing as 16 minutes.
No, there's a 26 minutes conversation.
Yes, not between a 20-minute tape.
Yeah, conversation.
Okay.
Whatever. The language.
Okay.
Between Jakpa and the AG. 26 minutes. And then you play 16 minutes. Where is the other 10 minutes?
So we can say, to determine that the conversation was 26 minutes, you would have recorded it to know that it was 26 minutes.
Yes, and you play the whole 26 minutes. You don't play 16. You don't put it out that I have a 26-minute tape. Then you come and play 16 minutes. Where's the 10 minutes? If it was 16 you wanted to play, you would have told us 16. So the 10 minutes, you see, even the expert, so that's my short answer to him. I don't need to condone it.
What do you think is missing? What do you think is missing?
I wouldn't know. I wouldn't know.
But you think that whatever is missing can be mitigating?
Whatever
can negate.
Yes, can negate what has transpired. You see, things have been pieced together. That is my understanding of what I heard. Now, that aspect of the medical excuse duty, if you listen to the conversation carefully, it just came up. No one heard what had transpired before this medical excuse duty came. It could all be that. I wasn't part of that conversation. But it could all be that maybe suggestions had been made. And then the Attorney General says, okay, if you want to absent yourself from court, then bring a medical excuse duty. How can that, per se, be piece of evidence in court? That's my friend.
You are saying it is possible that in that conversation, Jakpa would have told AG that he was unwell.
Maybe, just maybe.
But he said he was going to court the next day or so, and that he was ready. And then the AG said, I wanted you to delay it for me. And he said, you still come and meet me because I have a lot to do.
Samson, we'll all do ourselves a world of good if the whole 26 minutes
is played.
I'm not going to get myself into this.
Like now, you said, you and I were not there.
Yes. And then, how can this medical excuse duty be staged into evidence? If I bring a medical excuse duty to court, it is for the information. It is not evidence. We all know what evidence is in court. So how can a medical excuse duty be interpreted to be a piece of evidence? It's not.
He's saying that if a person who is healthy, who is well, goes to do that, they have deceived the court.
But that is not evidence. That is not evidence. But by what stretch of our understanding can that be evidence? It will have been deceit of court, yes. But can that be evidence?
It's
a factual misinformation. It cannot be evidence. It is not evidence. Unless I don't understand what evidence is. Unless you also don't understand what evidence is. Now, what again? What was the last one?
So,
criminal, yes. The criminal conduct.
Issues of crime.
Issues of crime.
Actually says this is also criminal. That you want somebody to go to the court to say they are unwell when they are well. He says that borders on crime.
It is not criminal. There is nothing criminal about it.
I was suggesting to him that could be misconduct.
Misconduct at the very least. How can that be a criminal? Okay. If you suggest that somebody should procure, even in the wildest interpretations of it, that somebody should go and procure a medical report.
On the basis of these developments, let's come here.
On the issue about the 26 minutes tape and this criminal.
So hold on. I'll come back to you. Right. When I get to you, you speak to that before you speak to what you have to say.
All right, Senior.
On the basis of this tape and what transpired in the court, and now even further affidavits on oath have been placed in the court, where the Attorney General has categorically denied all these claims. People, towering lawyers like Kweku and Sansari, former, director of the law school and director of legal education, Professor Kojo Appiagyei of the University of Ghana, and others say that the Attorney General's continuous stay in office is untenable. He either has to be sacked by the president or he must resign. You say this cannot happen.
I don't know who determines the misconduct of the Attorney General. In all the scenarios, what has been played out. I don't know who determines the conduct of the Attorney General. In any event, Samson, this piece of evidence, this tape recorded conversation that has been bandied about and thrown into the public domain, there's an ongoing trial. There's an ongoing trial in a court of competent jurisdiction.
I don't want to be in the shoes of this judge.
And the judge is doing her best to listen to the piece of evidence, the demeanor of the witnesses. At the end of the day, she's the best arbiter of what has transpired. Whichever way the case goes, there's always an appellate system. Jakpa had said something in court. The trial has not abated. It is ongoing. The Attorney General has not been given the opportunity on the threshold to even cross-examine.
It's not his turn yet.
So that we will all test the veracity of that loud proclamation.
And the Attorney General subscribes to a broadcast of the proceedings as requested by Ato Forson's counsel.
I would not be averse. I think in the best tradition, that is what we should be doing.
Well, the decision is for the CJ to
yes, I'm saying in the best tradition, that is what we should be doing. That if there's a matter which engages so much of the public attention, Ghanaians should be made to see what is happening. Of course, the election petition trials, we've all seen what went on in court.
All right.
But that decision lies solely at the discretion of the Chief Justice. I, sitting here, cannot make a decision for the Chief Justice.
All right.
If the Chief Justice feels that there is merit in a televised broadcast, so be it. Ghanaians will see what happens. Yes.
So if you say he must go, he must resign, in the face of you pointing to specific laws and rules of conduct that have been breached, the question he's asking is, who determines that the Attorney General has misconducted himself or has committed a crime?
All right.
It's not the public.
All right.
It is constituted authority.
Okay. All right. Now, before I come to that, let's put certain issues. You've been saying that often on Newsfile, when sometimes you say that, look, we are all lawyers. Let's put certain issues beyond dispute. Okay. So on the issue of fabrication of evidence, let me read what the law says. Section 214 of Act 29, the Criminal and Other Offences Act of Ghana. 213, let me start.
213. I have read it already, but you go on.
Whoever fabricates evidence with intent to defeat, obstruct, or pervert the course of justice in any proceeding shall be liable to the same penalties as if he had committed perjury in that proceeding. Now, 214 is where my focus is. Definition of fabrication.
Okay.
A person fabricates evidence if he causes any circumstance to exist or makes a false entry in any book, account, or record, or makes any document
with intent to mislead any
containing a false statement, or makes any document containing a false statement, or forges any document with intent to mislead any public officer, judge, or juror acting in a judicial proceeding. So when you tell a person who is fit and well to go and procure a medical excuse duty, what are you doing? You are causing a circumstance to exist.
So did he procure it?
You are making any document contain. You want him to make a document containing a false statement.
His question is to you is he never procured it.
Did he procure it? This is right. That's why we have inchoate offenses.
Inchoate.
There is a crime of attempt, so let's not even go there. So that settles it.
But
Number two.
The substantive question is, you are saying he must be sad, he should go.
Yes.
But he's telling you that must come through a constituted authority.
You said you were going to give me the chance to respond to a few things before I come there.
And we have to do it quick because we have to come to a close. Yes.
Is it not even amazing that we all sitting here as officers of the court, somebody will say that it doesn't matter that the Attorney General, who is supposed to be the Minister of Justice, will tell a person to forge a medical excuse duty to deceive a court.
Nobody has said it doesn't matter.
No, hold on. But the person says, did you do it? You didn't ask that question, but somebody asked that question. Did he do it? Should it even matter? Now, he says that
you can get a medical excuse
we put out in the public domain. Hold on. We put out in the public domain that we had a 26 minutes recording. That is a barefaced lie. We never said that anywhere. And I dare him to produce the proof. We said we're going to put out incontrovertible evidence that confirms Mr. Jakpa's assertions in court. And we did that.
You mentioned 26 minutes
conversation. I'm coming. No, but
you did.
But Samson, that is not the same as what he's saying.
Come on.
Listen to
How
my
did
words.
you come to mention 26 minutes conversation?
Dog. I'm saying that.
How did you measure the length of the conversation?
Hold on. I'm saying that. He says that we said we had a 26 minutes recording.
Which you did.
You said so. No, not 26 minutes recording.
No, 26 minute
conversation.
Yes.
So recording and conversation are not the same. Let's understand that.
How did you measure the length of the conversation?
Then number two, we measure the length of the conversation because when you make a WhatsApp call, as we put out, you see the WhatsApp screenshots. WhatsApp records the length of the conversation and you see there 26 minutes at 7:12 a.m., 9th April 2024. Now, this show is being recorded. Newsfile is being recorded. You may even upload the link on YouTube at some point. Let's say you have a technical challenge or your technical guy forgets to record this show from the beginning. And so at the end of the day, instead of 3 hours recording, you get 2 hours recording and you put it on your YouTube show, which I know does happen in the scheme of affairs here. Would that mean that because you didn't get the entire 3-hour recording, the 2 hours you got and uploaded is fake?
If I'm a judge, I will not pronounce that it is fake.
Yes.
But I will say that it is incomplete.
Yes.
And that the full extent may reveal what I do.
So first of all, let's deal with the two issues.
Right.
Number one, they are not saying it's incomplete, they are saying it's fake. And to that extent, you disagree with them.
Number
two, even with
they didn't say it's fake.
They say it's doctored. But when you say something is doctored, what does it mean?
It's not fake. Doctored means it exists, but you have done
something to it.
And I'm saying that.
And they actually use piece together.
Voice over piece together, incoherent.
Let's come to what they are saying. Okay. I'm saying that a tape cannot be said to be pieced together for the simple reason that you don't have the full conversation.
That's a fair point.
That is simple.
That's a fair point.
I mean, this is simple.
Then
number two,
to the end of the matter.
And number two, whether a tape is authentic or not has nothing to do with it being a recording of a full conversation or not. Number 3, we have told you that Mr. Jakpa, and he is ready to testify. He says in the sworn, statements under oath that is ready to bring that tape and be cross-examined on them. And we have already explained to you that it was in the course of the phone conversation.
Yes. Let's go to the end of this.
The recording
Let's go to the end of this.
Was done.
Yes.
That doesn't render the tape.
You are saying he shouldn't be in that
Again,
office.
he says that he's not an expert.
How can that happen?
Yes, he says he's not an expert, and I want to tell him what an expert thinks on this matter. Adam Bonner is an expert. He sat on this chair and said that as an expert, the tape is not doctored.
Somebody else can say otherwise. He's conflicted
because that is his relative.
He's very conflicted.
Yes.
Okay, but do you know of any expert who has said that the tape is doctored?
Sammy, can we get to the bottom
You
here?
want to rely on the account of a man who says he's not an expert?
You won't get to that.
I'm coming to that. But
Yes.
Samson, you ask questions and you don't want me to answer.
No.
You have to answer. Either than that, those watching us
The question I have
will
asked
get the
you-
wrong impression.
the question I have asked you-
The question is asking is what you are answering.
I have to answer.
The question is that you haven't answered.
But you are not answering.
So answer that one.
answering
Yes, go ahead.
that there is no evidence either in the public domain.
The question I asked you is this.
Oh,
you say he must go. He is asking you, how do you get him out there? It must take a constituted authority, correct?
What kind of hypocrisy is this? So in this country, we only call for people to resign or to be dismissed after a constituted body has made that determination. The Attorney General, you see,
You say he has committed an offense.
Hold on.
You say he has breached his code of conduct.
Exactly.
So
and I am saying that the Attorney General is a public officer.
Right.
He's also a lawyer. He's governed by the ethics of the legal profession. This is incontrovertible evidence of professional misconduct.
What happens?
Davis, his spokesperson, or the
what
Attorney
happens?
General has been disputed these issues
What
of
happens
professional
if you
misconduct.
say in the media
Yes.
that something has misconducted himself? Will I lose my license? Will I
that-
lose
if
my
that-
We are not
Decline in
just saying
Singa.
it. There is evidence to that effect. That is why
Untested
The
evidence.
evidence, what do you do?
Or untested evidence.
Yes.
What do you do with the evidence?
we just didn't ask him to. We just didn't ask for his dismissal or resignation. We asked for disciplinary proceedings.
How?
We asked for a motion of censure by the GLC.
How do you ask for disciplinary proceedings?
Either the
Have you-
GLC itself,
Oh.
okay, decide to take the matter up, or we trigger that with
Listens
a
to
petition.
the media
and
and
we
then-
are willing to trigger it with a necessary petition.
To
at the
trigger
right
it,
time.
trigger it, to trigger
And
it.
we have also said that there will be a motion for his censure by Parliament.
Okay,
You've
you have
started.
answered- you have answered the question.
And we have also said
Thank you.
that he lacks the integrity and the character required for a person to occupy that high.
Okay,
have
now
said-
And they cannot say that we should wait for a court to make an
you have said it
integrity.
so many times.
Thank you, gentlemen. Thank you. Kofi, Kweku Pinto, sorry. Kweku, Sammy, please. Kweku Pinto, Sammy.
When you are accusing
Sammy.
John Mahama falsely.
No.
When you are accusing John Mahama
Gentlemen.
for putting pressure on.
There is something important I need to get to Kweku
Did I
Pinto
say
you doing that
before
as a
we
trained
end.
lawyer?
What did I say that?
Is that what trained lawyers do?
Did I say that?
That John Mahama, there is
Did
no
I
citizen.
did I say
His blood is red.
Did I say
His
that
blood is green.
Mahama
This is
put
not
pressure
right.
on the
Yes, you
president?
said that in your press release.
Gentlemen.
You see, when confronted,
Please,
you are not
please,
beating a
please.
retreat. You said that about President Mahama.
Sammy,
You see, I didn't come here.
Can we end it here? Can we end it
said that
here?
about
Sorry.
President
I didn't come here to
Thank
engage.
you. Okay, so Kweku Yamua pencil.
Go and withdraw it.
Oh, please, let me do this show. Please, let me do this show.
Come to engage in a battle.
Sammy, Frank, please.
He's made false allegations
It's
against the person of
I
John Mahama.
don't want us
And
to
I
end this show
strictly
without
repeat,
Kweku
he can't
answering
stand
this
by those
question. Please hold on. Kweku, do you hear potential petition to the General Legal Council, potential censure,
Pencil is a government appointee.
potential appointee. Oh, how did I get there? This is not right.
He's a government appointee.
Potential censure motion. What do you say about that? How do you, if you have criminal complaints and misconduct complaints against the AG, what do you do? I'm asking you because I've heard you give some education about it.
As far as my knowledge is concerned, if you look at the LI that Leonard Friend quoted, which is Article 24, 23, there's no place for the Attorney General to be censured under that legislative instrument. And that's the end of that discussion. The Attorney General is a government appointee. He's not licensed by the GIDA, and his conduct is subject if you wish to a court of competent jurisdiction, you can bring any proper charges against him, but it's not subject to disciplinary code by the GIDA.
Okay, wait. The Attorney General, if you are not a lawyer, you cannot be an Attorney General, correct?
That is so.
All lawyers are subject to this disciplinary code, correct?
That is so.
Why is the Attorney General not subject to it?
Hello?
Why is the Attorney General not subject to it?
Hello?
Yes, Mr. Pinson, why is the Attorney General not subject to it?
You should have asked me a third question whether the Attorney General is also licensed by the GSC. It's not licensed by the GSC. I believe it's for political convenience, given his sensitive position.
Right.
I cannot give you the full reason behind it, but I believe that it's a political thing that our Constitution, as well as the legislative instrument, has conjured to ensure that the Attorney General is kept out of all of these matters, except by a court of competent jurisdiction. And therefore, if you have reason to believe that the Attorney General misconducted himself in any particular manner, then in my honest view, you must invoke the jurisdiction of the court. Of course, I've heard my good friend also saying that they want to subject to political censure, put it within their own domain. It's a political thing, and he may appropriately be subjected to that. But as to the outcome, I wouldn't be able to predict or make any decision, because political censures and whatever also belongs to the political domain.
So thanks for that education to the public about why a lawyer, leader of the bar, who also superintends over these rules somewhat, it's not subject to these rules. What rules is he subject to?
The laws of this country. As for the laws of this country, none of them prevent the Attorney General from answering to any allegation, like in the particular context of this case. Of course, the civil procedure rules can take care of any conduct or any alleged conduct. And obviously, in the absence of I heard my good friend talking about criminal prosecution. And of course, the problem with the criminal prosecution is that it takes the Attorney General to prosecute anybody in the country. So that one is out. And I wouldn't say that it is not for good reason that we have that provision for the Attorney General of this country. If we want to depart from that position, I know our Constitution has met with attempts to amend it and stuff like that. Maybe it's about time that we all gave it a thought and began to look at ways that Attorney General, in fact, not only the Attorney General is office, because I've made a point that there was ever a time that we wanted to bring an action, disciplinary action against a senior officer, the AG's officer. I'm talking about the senior state attorney, and the General Legal Counsel responded to our attempt by informing us that they don't have that kind of that power over the Attorney General and his staff. I mean, that's as simple as that.
Okay.
As to whether it's
nonetheless, you establish that there are not rules of conduct different for lawyers and prosecutors, correct?
No, there is no such thing.
These same rules
apply to them.
Right. Well, so those who are saying, Kweku Ansah and others who are suggesting maybe a commission of inquiry or something, and those who are pointing to Article 218, where Shraj has the power to investigate complaints of violations of fundamental rights and freedoms, injustice, corruption, abuse of power, and unfair treatment of any person by a public officer in the exercise of his official duties. Will that also apply?
No, I believe so. Because like you said, as for Shraj, they're very wide distant and they can investigate allegations, and that is part of their jurisdiction, except that nobody tried it in the case of the Attorney General before. But that's law. We test the law. So maybe you might advise the NDC that that's a possible avenue they may choose, but not before the General Legal Counsel.
Will it be your preference? Will it be your preference that these matters go before a constituted authority rather than the political football that it is in now?
I will not subscribe to political football, and I mean, because at the end of the day, what with due respect, my learned friend sitting there is doing, I'm even embarrassed. I mean, he's making all kinds of allegations, making all kinds of whatever. and at the same time he claims they are in court. And I wouldn't know which one he prefers, or whether he believes that he can join the two processes and still come and sit on television and make the kind of statements that he's making, including one or two allegations which are not even borne out by the law. He sat down there and was talking about, what do you call it? In the first place, he's talking about, I mean, I don't know whether I must continue this conversation.
Okay, so this is where we draw the curtains. We will not, don't say no, we will not continue. We will end it here. My guests have been Frank Davis, Chairman, Legal and Constitutional Committee of the New Patriotic Party. He's a senior lawyer. Kweku Yamwa Pencil is also a lawyer, very senior lawyer. We have had sorry. Mr. Pencil, government appointee. Yes, so I'm taking a break here. We had advertised that Kweku Ansasari may join us. He was unable to for some good reason. Sami Jemfi has also been here. Thank you also very much. Hope that we have helped and educated you. We'll be right back. I'll read your messages. We'll be right back.
Confirm to you that so far almost $12 million has been paid to the contractor. At today's exchange rate of about 16 CD, that translates to about 192 million Ghana cedis. And as you can see, nothing, and I mean nothing, is being done here. This is the taxpayers' money wasted. We visited the site for the constructor, and you can attest, the contractor has packed and left site. Not only has he abandoned the project, the chippings that he brought there, the few blocks that were molded to even construct the site, our information is that those blocks have been sold. The chippings has equally been sold, and so the taxpayers' money has gone down the drain. My checks in Accra indicates that the contractor has even left Ghana. We find this development very, very unfortunate.
You're welcome back. This is Newsfile, it's almost authoritative news analysis platform, and here on Newsfile, we put Ghana first. It's brought to you by the candid sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, that's your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. Syntex tanks, it's strong, it's tough, and Flamingo paints, it's simply superior. Now let's go through some of your messages. And Prince Henry Koforidia says the NPP should just provide the original voice between Jakpa and Godfrey Damio. We know that whatever the NDC played to us was doctored. Simple. As for President Akufo-Addo sacking Godfrey Dame, it's a big no. And for Godfrey Dame to resign himself, it's also a big no. The only way to find a solution and seek accountability from the NPP government is by doing a communal labor in voting out the NPP government led by Dr. Bawumia and okay, you will find a way to slot in your campaign. Okay, Kumi says that Frank Davis says the evidence given was that of a witness and cannot be objected to. Now the self-same person makes a U-turn, quite bewildering, especially, especially when you appear to be running away from your own contradictory submissions. Okay, that's the suggestion that is coming for. This one says, for the record, 26th of March, 2024, Mr. Sori appeared for Jakpa in court. The conversation on the phone happened on the 9th of April, 2024. I think there's no dispute about that. You know, we started the discussion in a certain way to establish certain facts to help you properly. And the fact that he was represented, I think, is not in question anymore. But even if he was not represented, there's a certain communication we have also educated you. It's not even permitted in the first place. This one says, this is Mark in the US. It says, when an attorney general engages an accused person on the phone, it is commonly referred to as a proffer, quote unquote, proffer, or proffer call, quote unquote. A proffer is an informal communication between a prosecutor, in the case, the attorney general, and a defendant, or the representative, typically to discuss the possibility of a plea agreement or cooperation. Whether it is proper for an attorney general to engage an accused person on the phone depends on various factors. And you mentioned jurisdiction. So we have told you what our law says. Our law does not allow this. Let's educate the public and educate them rightly.
Yeah, Senior, I wanted to make the point that Mr. Kwaku Pencil is an appointee of President Akufo-Addo, currently serving as the council chair for the University of Business and Integrated Development Studies. Not just that.
What's the point?
He is also a leading MPP member, and in 2008, filed to contest the Mfansimai seat. If you check the story, the legal battle.
Thank you.
And you know, in this
I'm reading messages.
Asabi,
we are not
going
going to
court with a recording tape.
We are not going to relitigate.
He went to court.
We are not going to relitigate. Sorry.
Saying that tapes are
Sammy, I beg you.
Sammy, court. Sammy, the legal battle for the Mfansimai West Parliament.
Sammy.
You know,
thank you.
Pencil,
Musa Abattoir.
You can see.
Musa Abattoir in Asawasi says the recent developments in the ambulance case, where Attorney General Dame is allegedly caught on tape trying to coerce star witness Richard Jakpa into giving he's an accused, into giving false testimony to implicate Ato Forson are deeply troubling and undermine the integrity of our legal system. Such action, if proven true, represent a serious breach of justice and an abuse of power. We must advocate for a legal system that operates free from coercion, corruption, and undue influence. You say, kindly ask Mr. Frank Davis, what crime did Mr. Ofosu Ampofo commit that he is being prosecuted in court for 5 years now? Okay, you remember that meeting and you remember the content. If you've forgotten, just Google it. This one, okay, you don't identify yourself. IQ. You say, please, it is important that you bring Sami Jemfi to book. His lack of candor, decency, and okay, you are insulting, so I can't read the rest of them because you're accusing and you are doing the same thing. Ken says, by the case authorizes the extension of without prejudice discussion can be tendered in court. It is the merit, substance, that is not permissible. Brobe spoke on that. I am watching the program, so I can furnish you with the law right now, but will do so subsequently. The existence of without prejudice communication can be tendered in court by submission. If a medical report is not evidence, then can the person who tenders it in court be cross-examined on it? It is evidence to prove you are not well. Abba. Okay. Then Theo says, providing medical excuse letter to court is evidence of proof of sickness when the person was not sick. So it is not evidence in proof of a case or defense in the criminal trial, but evidence to show that indeed the person tendering it to the court is indeed sick. Ernest says, all I ask in this is if the Attorney General knew all that he was doing is right, why was he worried he was being recorded? Truth always stands. In the interest of posterity, we must seek to exercise good judgment. Is Frank Davis saying if this was on the opposite side, he will proffer the same arguments? Let's put Ghana first. It's only the way to build our country. It's the only way to build our country. Bright, just a couple more and then we'll go to the next issue. Okay, Bright. Okay, you say you want the show to be repeated. The show is always repeated at 9 p.m. Kwame says, in television, editing is standard practice. It is when rushes or unedited material is cleaned up, either for clarity, expand repetition, or abridge long, meaningless pauses. The objective is not to alter meaning. To doctor, in my opinion, occurs when original sequence is rearranged or foreign material is introduced. So editing is not necessarily doctoring. Above the act, I think doctoring presupposes ill intent. Matt Baton, if a minister is engaged with a scandal that seemingly affects the image of his government, it doesn't necessarily have to be true to compel such an official to resign. Okay, so you join Kukua Sasari and Professor Apieje Junior Masaudu. In fact, Godfrey Dame, Samson, what any good prosecutor will do is to have accepted the plea bargain of about 90% before looking at anything else. Harry Olufawa says Dame should have resigned the moment the audio recording came out. He has compromised his office, his profession, and his person. He is an embarrassment to the administration. Kojo Dodd says audio tape and WhatsApp messages with Mr. Jakpa have made Mr. Dame utterly unfit for the office. He should resign, or the president should do the needful. Eja Amachi says we are gradually becoming a dangerous society. People misbehave, and we do everything we can to shield them because it is our party person. Finally, D for T. If I were Dame's family, his colleague, his genuine friend, and I had listened to the tape, I'll advise him to lay down his pen and prepare adequately to prove his innocence. Well, that is why I advocate that let's stop the political football and get it into a forum where the proper thing will be done. I think I'll take a quick break and return to Professor Minla and the rest of them to get us for us to understand why Sammy stopped misbehaving. We'll be right back. You're welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile we put Ghana first, and we have very limited time, 30 minutes, to canvass this Pwalugu Dam matter for you. According to those responsible, the explanation they have brought forward over the matters in respect of the expenditure of about $12 million with no work to show for. Their explanation is that it was used for drawings, some surveys, and other things, including cutting a path to the place and, pitching a camp for the workers that will need to use the place. Now, the question is, should that not earn the country more than it has? Professor David Miller is former Pro-Vice Chancellor for the UDS and President of the Miller Open University in Bolgatanga. Okay, that one too. Today, I'm falling for all of the wrong things. It's Bolgatanga, and we say Bolgatanga, but you can't run away from it. Dr. Charles Nyaba, former Executive Director, Peasant Farmers Association, Sami Jemfi, is still here with us. This is what we're going to do. Because Prof will speak on substantive matters regarding the viability of the Pwalugu Dam, we will hold him for a while and deal with the question of the amount spent. You don't take the explanations that have come so far briefly from you before I go to Charles.
Not at all, because the explanations are not tenable. Not tenable because, okay, but first of all, it is not in doubt that payment to the tune of almost $12 million has been
11.9.
Yeah, to the company. That's a huge amount of money, okay? Now, it is also not in doubt that when the governor of the Bank of Ghana, the body that made that payment, appeared before the Public Accounts Committee and he was asked the basis for the payment, he could not substantiate it. He referred the question to his auditors. The auditors also could not substantiate the payment. It's been more than a month since that happened in Parliament. It is only now that we are seeing a statement from GIDA attempting to explain the basis of the payment. And they justify the payment by saying that the amount was used for certain studies, topography study, environmental impact assessment, soil test, and the rest. And that the amount of money was part of mobilization. The contractor has used it for certain access rules and his campsite and all that. Now, our position on this is clear. This explanation, belated explanation from GIDA, is completely contrived. Because the feasibility, if you check VRE's own website, they say that the feasibility for the Pwalugu Multipurpose Irrigation Dam was done by VRE between 2013 and 2018. 2013 and 2018. And all the things GIDA claims this payment we are talking about was used for were done as part of the feasibility between 2013 and 2018. And the Minister for Agric...
They say the things that were done are these.
Yeah.
Environmental and social impact assessment,
Yeah.
December 2020. Topographic survey and mapping, November 2021. Geology and geotechnical studies and drawings, November 2021. Soil and land suitability assessment, November 2021. Design report and drawings in parts 1 to 3, November 2021. Resettlement action plan, March 2022. And cadastral survey, July 2022. These are the things that have been done.
So, and Samson, our point is simple. These don't form part of the mobilization of a contractor. Environmental impact assessment was done together.
Construction of access road.
I'll come there.
Contractors.
I'll come to the construction
site and offices.
and the campsite.
Construction of temporary and auxiliary
Exactly.
facilities.
So I'll come to the construction part. I want to talk about the investigative reports they claim the contractor has done. You can talk to any expert in the field. Those don't form parts of mobilization. And the Minister for Agric himself is reported by the media, specifically Modern Ghana, okay, to have said that Pwalugu Multipurpose Dam feasibility studies cost $60 to $70 million. Construction cost $1 billion. Listen to the headline. Pwalugu Multipurpose Dam feasibility studies cost $60 to $70 million. Construction cost $1 billion. If you read the story, the minister explains that they've done environmental impact assessment, feasibility, all the tests you mentioned. And the cost is $60 to $70 million. That is what led...
The contractor did raise a bank guarantee of $60 million.
No, we have not even got into that place. We are talking... They say, the Auditor General says the Bank of Ghana has paid almost $12 million to the contractor. And together with the journalists, multimedia, we are saying we've been to the site. There is no evidence of actual work done. Now, GIDA comes in to explain the work that the $12 million has been used for. And they are talking about environmental impact assessment and other preliminary works that borders on feasibility. So we are saying in response to that those works, those feasibility works, there is a cost to that. According to the Minister for Agric, $60 to $70 million, separate from the contract given the contractor, which is about $1 billion.
Oh, that's your understanding.
That is what the fact says. You understand? So the feasibility, all these investigations preceded the payment of the mobilization to the contractor. Preceded. All those things had to be done before the cost of the contract could even be put together. Because if you have not done the soil test, how will you know the kind of dam to build and the cost of that dam? So they had done everything, and according to the Minister of Agric, the cost was $60 to $70 million. Government has paid. They now award a contract to a contractor, and they have paid him $12 million for no work done. So they can't say that the preliminary works that the state has already paid for is what they use the $12 million for. Now to the construction leg of their claim. Samson, I'm happy with the kind of attention multimedia has given this story. And I want to throw another challenge because I have already done my background work. And I can tell you that there is no access road from Sariba to Pasenchi, forgive me if I get that name wrong, that connects Sariba to the campsite or the project site. No access road. If you are talking about the removal of shrubs or a bulldozer moving through a bushy area, and that create, you know the topography of the north, and that creates a kind of path, fine. But they can't talk about 5.2 kilometer access road. It doesn't exist. They can't talk about 4.2 kilometer access road. It doesn't exist. And I will be very happy if you can send your reporter there again. It is not there. If it comes to the campsite the contractor has created, you've seen it. What? Container and all that. Does that warrant the expenditure of a colossal $12 million? No. So, Samson, this matter is clearly indefensible.
Okay.
The media, we commend you for following it up. We commend our members of parliament. We are all going to follow this matter up and pursue it to its logical conclusion, which is that the payments that have been made for no work done must be retrieved for the state for developmental purposes.
Is that not too early to say? Because there's a project, the cost of the project is $993 million US dollars. Yes. So why don't we wait till we get to the...
Because the project was supposed to last for 4 years. The duration was 4 years. We have gone past the 4 years.
But they have explained that there have been difficulties financially.
There is no way.
That is why we were...
In all honesty, tell me.
The money the government
if for 4.5 years,
access.
If for 4.5 years, government has not been able to raise the money, is it the 6 months they have left that they will be able to raise almost $1 billion? This broke government that can't even pay contractors, can they raise it?
Okay, let me go to Charles.
Let's retrieve the money for us.
Thank you very much, Sammy. Thank you very much.
The corruption is too much.
Thank you, and thank you for joining us this morning.
Thank you.
Now, Charles, what should we be looking at? What's the problem? The explanation by the Ghana Irrigation Development Authority, GIDA, is it GIDA or GIDA? Sounds like GIDA, yeah? GIDA. GIDA brought us trouble. Let's hope that GIDA doesn't bring us trouble. What should we be looking at? Why do you doubt the explanation, if you do? Hello, Charles. Hi, Charles Nyaba. Please unmute your mic.
Okay. Can you hear me?
I can hear you.
Yeah. I'm saying that if you permit me, let me just give a brief history why peasant farmers are so much interested in this project, because it's our brain project. Prior to the 2016 elections, we had what we call the Farmers Manifesto, where we looked at the priority areas that we think that any of the parties that will consider them in their manifestos will consider and vote that party in power. So we did engage MPP, and at the time we made a series of proposals concerning the need to develop our irrigation infrastructure. And one of the proposals we made was the one village, one dam concept, which was accepted. Pwalugu Dam was one of the areas that we discussed with them. Temde Dam in the Timpani was one of the other dams that raised those concerns. We said that because if you look at the areas where our people are, we have over 90% of them being farmers. Now, for the past 1 decade, we realized that the raining pattern changed, the volumes changed. So around December, November, you see the youth, the young women, trooping to the southern sector to look for jobs because the grain-fed agriculture was no more attractive to them. So when they accepted our proposal, we all went to rural areas, said, okay, if that's the case, we need to give them opportunity to grow. With the hope that when they come, they will implement that. So if you look at the voting pattern in 2016, you realize that when you go to Upper East, Northeast, Upper West, Northern region, Bono Oti region, MPP votes increased drastically because we were hoping that these proposals would be accepted. After the 2016 elections, we keep monitoring these projects. You would have remembered our advocacy on the One Village, One Dam. Along the line, the way the One Dam, One Village was implemented, we were not happy. So we did engage, and then we were promised that at least there will be some kind of reforms to ensure that they are properly implemented. Again, in 2019, the sword was cut for the Pwalugu Dam. We were also monitoring. In 2022, October 27, all our members in Upper East and Northeast region, together with the chief, we went to the site and realized that our expectations were not met. So we did a march in the Nalirgu. We had an engagement with the Nairi. After that, Bomia called us to the Flagstar House, where we had engagement, and he gave us another promise that for now there's lack of funding, but he's going to do everything within his power to ensure that funding is allocated for the construction of the dam. Around that time, we never knew that 11.9 million was already paid to the contractor, because as at the time we visited the site, there was no work done there. Now, the following year, that's 2023, in the agriculture budget, 250 million Ghana cedis was allocated for the construction of the dam. We were further disappointed when it came to the mid-year budget, that money was taken out. So when the Public Account Committee brought out this information, for the past 2 weeks, we never had rest in the office. We got calls from the members around the area, for farmers. They think that this money is so much that they will pay that for only mobilization without seeing anywhere done. And I'm also thinking so, because if you look at the One Village, One Dam, each dam was costing 250,000 Ghana cedis. At least we saw some kind of excavation, some kind of small work done, except that the dam didn't meet standard for agricultural purposes. But in this case, we are not even seeing anything. So for us as an association, we are not too much concerned about the politics part of the discussion, but we want to see that if 11.9 billion is paid, we want to see some kind of something that at least our farmers can use for something. But as it stands now, we think there's no goal for the 11.9 million. And we are looking to hear, in going forward, what measures are going to be put in place to ensure that we have the Pwalugu Multipurpose Dam.
Is it true that the contractor has abandoned site?
Yeah. Last week we visited there. There's no sign of any contractor there. There were some few chippings the time we visited in 2022, and then some blocks at the site. But later on, all those chippings were gone. There was nothing there. To be very honest with you.
Yes. Okay, his line dropped, but his point has been made. Let's go to Professor Miller now. Because he has a certain background he wants to bring for us to appreciate whether or not this is a project that we should continue despite the issues that have been raised. And as you can see, is that the road they talk about? The road that has been constructed and the money has been spent? Oh, that's it. So that's why the members of parliament who visited the place said a path rather than a road. This is all there is. Those of you who have the benefit of the television, this is not good. Look, it's a very serious matter, but you can't help it. Yes. Yeah. Charles, do we have you back?
Yes, that's on.
Okay, Charles, describe what you are seeing on the screen to our viewers. Where is this?
So now I've no access to the screen, but what I was seeing is that we visited a site, and then Saturday, apart from the just parents, the trees and the sort of paved way visit the site, there's not a site. The camps that are constructed in a different community, far away from the dam site. But the depth dam, it was separate. And then some farmers could pass right other way to stop the dam. But there was no done.
Oh, your line is not the best. Your line is not the best. Let's hear John Jinapo when they visited the place. Let's hear what he has to say. Once again, to put matters in perspective for you as we try to get a clean line to Charles Nyaba or Professor Minla if we can get them. So let's hear John Jinapo.
I can confirm to you that so far almost $12 million has been paid to the contractor. At today's exchange rate of about 16 CD, that translates to about 192 million Ghana cedis. And as you can see, nothing, and I mean nothing, is being done here. This is the taxpayers' money wasted. We visited the site for the constructor, and you can attest, the contractor has packed and left site. Not only has he abandoned the project, the chippings that he brought there, the few blocks that were molded to even construct the site, our information is that those blocks have been sold. The chippings has equally been sold, and so the taxpayers' money has gone down the drain. My checks in Accra indicates that the contractor has even left Ghana. We find this development very, very unfortunate.
Right. Okay, Charles, are you back clearly on it?
Yes, please.
Okay. I was asking if you were able to see the footage that we were showing.
Yeah, so to be honest with you, even though I haven't seen them, but I also have a first-hand information about the situation now. When we visited the site,
when?
Those things that were described by GIDA.
When did you visit?
That was in December 2023.
Okay.
Yeah, those things that were described by GIDA as being constructed, we haven't seen them. They come.
Not at all. Not at all.
Hello?
You said you hadn't seen them. I'm asking, not at all.
Not at all.
Oh,
they
come
come,
on.
so they come.
Sami Jamfi speaks about what he saw, but it shouldn't be worth the expenditure.
No, it doesn't work. What we saw there, as a layman, I don't think it will cost more than $1 million. Because there was virtually nothing. Apart from the clearing of the trees, where farmers were now using the dam floor to plant okra, to plant rice and other vegetables. There was not any contract construction work that was done. The act that is was just that they used GIDA to play it to allow access to site. Okay, they come for the camp. I get, but I spotted them and I never.
Charles's line is still very bad, very unfortunate. But the pictures you are seeing, for those of you who don't have the benefit of the television, it's complete bare land, and then you see some gravel, or chippings that have been. How many trips will that be? Sitting. Two different extremes of the place, and then you see some blocks that have been molded around there. They are just actually the weeds are growing over them, and it's a bare land. And unless the media went to the wrong place and the members of parliament who went to for the inspection went to the wrong place, this is the road that the authority, the Ghana Irrigation Authority, Development Authority, is referring to, that it says has been constructed, and all of that, is supposed to be what is costing us. Sword was cut for this project on the 29th of November 2019, and it was supposed to be completed within 4 years and 6 months. The first component of it involves a 60 megawatt hydropower and 50 megawatt solar power. And then the second component is the irrigation infrastructure. The cost together is 993 million. The first component is 5 million plus, and then the second component is 4 million plus. The project was awarded as 2 independent engineering and procurement construction contracts to Messrs. Power Construction Corporation of China, that is Power China. It consisted of a detailed feasibility study and engineering, construction, all pre-construction activities that were required for actual construction. This is what they are telling us the monies have been spent on. It's a very difficult place. The expected mobilization payment from government was the amount of 48.57 million. And then after receiving advance payment guarantee, government paid the 11.94 million, which is 25% of the total mobilization that is required. And yet there is nothing on the ground. But this is the justification we are getting, that they commenced mobilization to the site in April of 2021. Then engineering designs, major output of the project design has been submitted. You know, okay, so I suppose that under the circumstances, we will just have to follow. They say it's a 5.2 kilometer access road that has been constructed. And then there is also the contractor's camp, 4 kilometers on site and around the camp have been completed, 11 blocks of building, 100 rooms as site offices. Construction area and main structures are completed, except for water and electricity. Please, what am I reading? I'm reading from a statement that they have issued. And look, clearly the media and the MPs, they went to the wrong place. Yes, from what we are reading, they went to the wrong place. They couldn't have gone to the site where they were showing a bare land and blocks and some chippings that were sitting there. You know, initial financing of $2 billion with Sino Hydro Corporation Limited in September 2022 has stalled, and government has been forced to fall on the regular budget to finance. Government is seeking alternative funding sources. Contractor has agreed to halt works on the project. Okay. Now one can appreciate why people are comparing this to the National Cathedral project, but this is a very important project. It's a project that's supposed to hold water when it is spilled from the Bagri Dam, and it causes death, rather than, you know, holding the water for irrigation purposes and for power. And this is where we are with it. Professor David Miller, thank you for making time to join us.
Thank you, sir.
We have just about 3 minutes to draw the curtains on this. Just help us within the next 2-3 minutes. What do you have to say about the developments? How do you feel about it? Being someone who has been very passionate and excited about the prospects of this project.
Yeah, well, it's a pity that there is nothing to refer to as a project. Because the objectives of the project, like you summarized, includes building a dam. In fact, building 2 dams. There's a dam and there's a weir. A weir is a lower dam, a smaller dam. That will boost the water for use for irrigation. So that facility was to be provided, and the facility would provide solar and hydro energy. Then it will go into irrigation. It It will do a 30,000 population water supply to Walwale. Then it will be used for fishing purposes and the township belt and a lot of road networks. So it's a multi-purpose project. But unfortunately, the takeoff has been flooded with a lot of problems. So there is, for me, there's nothing that I can call as a project success story. Yeah.
Very unfortunate. Thank you very much for your time, Prof. We will have to find a special time and sit down with you because of your knowledge and your passion about this project and what the prospects are for the northern parts of the country. This is not only for the upper region or the upper east and the other northeast and so. Thank you very much. Thank you indeed. Now, let's me let you know that this show, my outfit, as always, is by Konati Clothing. And Konati Clothing is doing something special, as I announced to you last week. If you make your orders between now and Father's Day, and between now and the Muslim celebration that is coming up, you get between 10 to 15% discounts. Konati Clothing is at Adenta Shopping Center, Adenta Down. You can call them 0244 676732, 0244 676732. And join me tomorrow afternoon on my favorite show, The Law. Last week, I hope you enjoyed the Chief Justice who was on the show. Tomorrow at 2 p.m., I'm engaging Professor Stephen Kweku Asari. You know him as Kweku Azar. After the Supreme Court's decision that has lifted some of the barriers on dual citizens and their capacity to hold certain offices in Ghana, we ask the question, what is next? We'll delve into the decision of the Supreme Court and ask what must happen next. I'm Samson, Lardy, Anyenini. Have a good afternoon.